Welcome to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts in this conversation about survivors of violence navigating the BC family law system. We recognize that this system is colonial and causes harm to families, and that disproportionately impacts Indigenous people.
By speaking more widely about these harms, we hope to raise awareness about the challenges that survivors face as they navigate the colonial family law system. This podcast is our attempt to collectively identify the barriers and ask for positive changes to be made. Thank you for joining us. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence, including physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope that you will take care of yourselves however you need.
Hi, Stephanie Melnick here, welcoming you to episode 10 of You Can't Say That in Court. Today, we start a 5-part series about legal intersections with family law. Vicky and I recorded this conversation with 2 other lawyers last year, but find that the observations are quite relevant today, which is why we're sharing it here through the podcast. When we planned this, we invited a lawyer panel to discuss the problems of when family law overlaps with specifically immigration, criminal, and child protection law or family policing. And the discussion is a little more technical, a little more legalese than our other episodes. So it might appeal to any lawyers or judges out there listening, but I also think it's a really good recording for survivors so they hear that their frustrations are shared by lawyers who are part of the system, as well as being useful for any other court workers or support workers. Actually, everyone can probably benefit from hearing this conversation. So we have Stephanie Hodgson from episodes 3 and 4 back to join us. Steph H is a lawyer on so-called Vancouver Island, working in the areas of family policing and family law. And we're welcoming for the first time Melissa Klages, managing lawyer at Arrow Law in what is colonially known as Revelstoke, which is also where I live. Melissa will be speaking from her experience in both criminal and family law. And lastly, our own Vicky Law is participating as a panelist, relying on her experience in immigration and family law. We're going to jump into this conversation where I invite each of the panelists to outline how the overlap of these different areas of law can be used as a manipulation to cause harm. So here we go.
There are a number of themes I expect will emerge, but let's dive into coercive and controlling behavior first. So if we're looking at situations where family violence is present or a survivor of abuse is navigating legal systems, we want to talk a bit about what it looks like when the abuser uses multiple systems to perpetuate specifically coercive and controlling behavior. So Vicky, maybe I'll pass it to you to start, and you can talk about just the beginnings of what the behavior looks like in the context of immigration law.
Sure. Thanks, Stephanie. There's multiple ways that abusers can use the immigration system to perpetuate controlling and coercive behavior. Let's first talk about what that behavior can look like when the parties are still in a relationship. Oftentimes, abusers will threaten the victim or survivor of violence by saying, I'm going to call immigration because you don't have status. Or if you don't do this, I'm going to call immigration and have them deport you. These are often threats that we hear survivors disclosing to us. And it doesn't matter whether or not the survivor does have status or not, because oftentimes we understand that abusers control information. They control the finances and they control the information by giving limited or no information to the survivor at all. And information in terms of immigration context can be the status of the survivor. So a lot of times survivors come to us as immigration lawyers and say, well, we met with an immigration lawyer or we met with an immigration consultant and I did sign something, but I don't know what I signed. And I don't know if that application was actually submitted. I don't know if it was approved. I I don't know. Or the survivor can be like, he promised to sponsor me. He promised to regularize my immigration status. And he said he sent it in, but I've never seen anything and I don't know. And so survivors are often left in the dark with the lack of information. And so these threats that are being made, I will call immigration to deport you, are quite valid in the survivor's mind because they don't know what their status is. Another threat that can come to survivors is, I will deport you and I will take the children away from you. That is another quite serious threat that many survivors do believe, because the abuser probably does have status in Canada and is able to stay in the country. The children have status and are able to stay in the country, and she's the one without the status. So the fear of her being deported and being separated from her children is a very valid fear.
Vicky.
And even, oh, yes.
Yeah, I was just going to say, we see this parallel in family policing and child protection law as well, especially when folks get to a situation where social workers are involved. There's a threat that children will be apprehended, will be removed from a family. And questions that I will ask my clients often, and very gently probing, like, was there a specific reason why you didn't access supports or services before things got so serious? And many times the answer is, well, he threatened to call the social worker. He knew that I was the one perhaps using alcohol or drugs to in my life, where the abuser has the upper hand, and they're going, you know as well as I do, if I call a social worker, they're going to make you leave and I'll be here with the kids. You're going to have to go somewhere else. So I see a direct parallel when folks are still in relationships. And of course, in family policing, it's important to note that oftentimes the parents are still very much in a relationship when they're dealing with these legal issues. So it can be an ongoing theme where there's abuse in a relationship and it's this tumultuous situation of, well, I know I have the power. So if I decide that you're not going to be here, you're not going to be here. And we see that, we see very similar things over on this side as well.
Yeah, and that mirrors for survivors who don't have immigration status, right? Oftentimes we're like, why didn't you call for support? Why didn't you call the police? And the survivor's response oftentimes is, well, I don't have status. I'm worried that the police is going to deport me if I call for any help, for safety concerns. So a lot of parallels for sure. And the last example that I want to give for immigration is, and this still happens, is the abuser calling immigration and reporting allegedly that the survivor took advantage of them and it was a marriage of convenience and that the survivor used the abuser in order to get an immigration status. And then that could potentially lead to a whole investigation into the survivor and the obligation on the survivor to prove the genuineness of the relationship.
Yeah, I'm already detecting a couple of themes. One of them being that the abuser is confident in being able to mold the reality for the victim or the survivor. And I feel like that probably comes into play a little bit in the criminal realm as well, when we're talking about criminal law. Melissa, do you have
Yeah, it's interesting the comment about there's patterns of behavior before the relationship ends, and those patterns tend to continue. I've noticed that sometimes before separation, the abuser will use threats like questioning the ability of the mother, setting the tone of, well, if you're going to do something, I might suggest that you have whatever, drug and alcohol issues, something like that, so that mom feels very nervous about going forward because that's a scary threat for a parent to face. Another thing we've noticed in small towns is on the cusp of separation, we'll say man will call the offices in town and try and create relationships so that maybe she can't use these offices. And I've responded by having policies and procedures in my office that will prevent that from happening. Also, I sometimes I meet with women who have such low confidence at the outset that that's been building, so that by the time separation occurs, her confidence is very low and her perception of what's going on might not be accurate. And so there's a bit of a setting the stage that can occur. Also, I've encountered many people that can't pay for consultation fees. And so I have the luxury of responding with a practice that can accommodate that. And so that people aren't hamstrung by access to finances. Then within the system, like often we deal with families that have criminal proceedings, maybe based on physical or sexual assault, but then also FLA proceedings with respect to the children and perhaps finances. So then within those proceedings, you'll see lots of things. For example, the abuser bringing lots of what I would call frivolous applications. Like, I want to get the kids at 2 instead of 4, or that soaks up mom's time and energy and legal just ability to respond to. She gets overwhelmed by the paperwork and so forth. So doing things to erode her confidence as she navigates the systems, being difficult within the FLA proceedings. And when I say difficult, taking unreasonable positions sometimes with respect to the children or parenting time to try and hurt mom is my thought on that. And also the logistics of it. So in rural towns, there might be Supreme Court proceedings that are in Kamloops, but now we also might have provincial proceedings there in Revelstoke. And just the ability for people to travel and attend to those things and file financial statements and so forth, it can get really overwhelming. So if the abuser has more access to finances and that sort of thing, they can use the system to sort of erode mom's ability to continue. And sometimes you may not know about all the proceedings. Like, there've been proceedings have started in Supreme, and then you bring provincial ones for support, and it takes a lot of work to navigate those. So sometimes you have to rally people's energy in order to help them to continue.
Yeah, it's interesting that you bring up the frivolous applications through court proceedings, but then also the conflicting out strategy prior to. These are two very prevalent examples that we've talked about before in other training sessions as being prime examples of abuse of the court systems and of the legal systems, and just perpetuating the coercive and controlling behavior that an abuser had in the relationship and then continues to do through the legal system. But I feel like I would just cut someone off.
Oh,
So
thank you, Stephanie.
Yeah,
I was just going to say, yeah, the conflicting folks out. We've had recently an announcement from the provincial government after a decision came down. They've referred to as single mothers. The single mothers decision came down. And so on a governmental level, the the government of British Columbia has said, okay, we're going to fund a clinic. It'll be through Legal Aid BC. It will be focusing on trauma-informed practice. It will be specific to clients who are fleeing relationships with family violence aspects and dealing with family law. And what I understand is that once this clinic is up and running, it will be I believe it will be one clinic. We don't have the full information, but my first thought was, well, isn't that great for whoever gets there first? And we see that a lot in family policing. We see it a lot with the Parents Legal Centers, which is a collaborative program. For those who don't know, in BC, there are 9, I believe now, around the province. Excuse me. And the issue comes often when the higher resourced, lower needs member of the couple accesses the Parents Legal Center, and so they get full support. They have access to an advocate within the office. There's administrative support. It's a beautiful office. I've been in a number of them. I worked in one of them in Victoria. It's a beautiful, big office. And then we see the other member of the couple, the other parent, who in Vancouver or lower mainland or Victoria generally won't have too much trouble being assigned a legal aid lawyer, but outside of those two areas, it can be very difficult to find a lawyer to be assigned to, and especially for family law. It's the number of emails I get from intake staff at Legal Aid saying, hey, can you take this file? And oftentimes I'm conflicted out. And we also see folks who, and Melissa, when you were mentioning the frivolous or vexatious is the other word that gets used, applications in court, certainly there are court centers where mom will come forward and the judge will ask, well, did you talk to duty counsel? And mom will say, my ex-spouse, my ex-partner has spoken to every lawyer in the area who does this type of work. There is no one I can talk to. And I don't drive, or I have limited ability to travel. I'm taking care of the kids, so I have children that I need to be picking up and dropping off and caring for full time in a lot of cases. And there is no option. I mean, thankfully there are telephone options. There are a few more options out there, but that situation where the parent who is the recipient of the abusive behavior simply cannot access, even though they have the energy. And oftentimes, in cases, they're using that energy in a way that if they had an assigned lawyer, that's where the energy could go. So I resonate with that, with your comment about energy, Melissa, because oftentimes that's right. The question is, very gently, why didn't you seek out? Is there a reason you didn't seek out supports and services earlier? And a lot of the times the answer is because I'm dealing with so much, the client is dealing with so much that finding or bothering legal aid to they've been approved, but they haven't been assigned someone, bothering legal aid to get assigned a lawyer is so far down the list of priorities that it gets to a point of removal. It gets to a point of threat of removal, imminent threat of removal. And then on top of that, dealing with concerns about housing, about food security, about healthcare, about, no family doctor, so on. And the layers just keep building. So I'm glad, that's one of the reasons I'm glad we're doing this talk, because it's important to acknowledge on a systemic level. It's not just, it's not just 4 different levels of the legal system. It's so much more that our clients are dealing with. So here we are.
Yeah, it's interesting about the conversation of energy, because when Stephanie Malik and I traveled around BC in 2022, so many communities have said, our clients don't even touch the legal system, whether it's family law or immigration or criminal, unless they're forced to, obviously, but because they are dealing with the basic necessities of housing was a huge one, right? And so it's the hierarchy of priorities, what can this person work with right now? What do they need to deal with? And in certain communities, legal support is very minimal or none, zero, that there is no capacity to try and reach out for those supports. And that's something that we've heard quite often in our travel.
Yeah, and it's tricky when we write about it, because we're describing that these basic needs that are absolutely essential for everyone to be able to function and take care of their families and are absolutely the priority, take a ton of energy. And if abusive behavior is also happening on the court level or within legal proceedings, then that's a whole other layer. It's almost like it's a privilege to be able to engage in the legal system, because it's a level up from taking care of the basics. But when writing about that, it almost comes across as if the client is lazy. The concern is that someone who doesn't understand actually how difficult it is to live with that level of stress and abuse. It's not laziness at all. It literally is survival in a lot of cases. So it's very difficult to convey that the legal system is a whole other layer of energy required in order to be able to reach the end, to get to conclusion as well. Yeah.
Well, the other thing
Go ahead,
Melissa.
Melissa.
Lots to say, but I was just going to note that often here, if someone's charged and they meet the qualifications in terms of finances, they'll often get a legal aid lawyer for criminal matters. But the spouse who's looking for a legal aid lawyer for family matters, they have a really hard time, like Stephanie said, finding family law lawyers that can take the files. And so you have a represented spouse in the criminal matters, which will be advocating to Crown for certain things and feeding Crown information, but you might not have that for the other spouse. And the institutional barriers of the forms can be so overwhelming for people, the provincial court family forms now, and the necessity of filing the financial statement and having your taxes done and all that sort of initial legwork that you should do according to the rules is really overwhelming for some people. And it's tough for lawyers always to do that back work when you're doing the other work that's required. So obviously there's institutional barriers that we are all aware of and that need to change.
Well, and for anybody who's not familiar with the application about a family law matter under the provincial court rules, like I'm going to save one today. So is it 54? Is it 52 pages? Like
I remember thinking it was 43 and they keep changing it.
Oh yeah, no, because they included they've changed the law, of course, to do with animals, right? Animals are no longer considered like pets aren't considered straight across property in BC anymore, just as recently. And yeah, my PDF program, which is usually so reliable, has chosen this moment not to be. But yeah, like it's 52 or 54 pages of PDF. And half of that is guide pages, is instructional pages. But when I'm on the law line and when I have new clients who have never seen the form before, I warn them in advance. I say, listen, this is a very overwhelming form. It is huge. And they laugh. And then I say, it's 54 pages. And they stop laughing. And a lot of folks, when they have seen it and they don't have any supports with them, they immediately shut down and go, I can't do this. I could never do this. And the secondary part of it, of course, is going, you are not responsible for every single page here. But when a human being is presented with a 54-page PDF and it all, especially, and we haven't mentioned yet, like literacy concerns. We, as the professionals, the folks who do the jobs that we do, like there's an assumption of a certain amount of literacy that we have. In my practice, I've learned I can't assume that my clients have a high school education. I can't assume that they're not dealing with learning disabilities. I've had clients, certainly a number of clients who have a very minimal reading level. They can text and do emojis, but asking them to like reading an email, there's no point. There's no point. So presenting somebody with limited literacy with a 54-page PDF and saying, go ahead, figure out which parts of this apply to you, because they don't all. Figure out which parts. That ends up with our own clients filing applications with pieces that don't apply to them because they simply weren't aware they didn't have to do literally the entire form, or they didn't realize that for parenting arrangements, there's parenting arrangements where there's no written agreement or order, and then there's parenting arrangements where there is already an agreement or order, and the difference between an order and agreement. Folks don't, right? There's that level of just legal knowledge, which for folks who do it all the time, ourselves, it's rote, right? It's every day. However, for someone who's never done it before, going, I don't know, do I have an order? Mm-hmm. Maybe. Do I have a written agreement? I have no idea. Does a text message count? I don't know. It's right. So that very basic piece plus the giant PDF. And I mean, I tell folks every time I have somebody say, I'm so overwhelmed by this form, I say, listen, there are lawyers working really hard to get these forms changed. It just seems to get longer though. Like, to be honest, don't know what's going to happen. Anyway, that's my note on the ridiculous PDF form. And just to say, my PDF program has officially crashed. So there you go.
That says it all. That says it all right there. Exactly.
Yeah. Yeah.
This is all really good groundwork for maybe progressing into more complicated areas of all the intersections. But before I move you on to that more complex area, was there anything else any of you wanted to say just about your specific areas of either criminal, immigration, or family policing, just on its own? No, we're okay?
Yeah, feels good right now. Yeah.
Okay, good.
Thanks for listening today. Our panelists have started outlining the challenges people face in these legal systems and the ways court-related abuse can happen when they overlap. This lays the groundwork for our next episode, where we continue talking about how complicated it gets when different legal systems are working at once and why it gets messy even for lawyers to navigate. So we'll see you next time.